So I will admit that I was planning on continuing looking at the derivative use interview today. However, yesterday's video that I did where I was doing a breakdown, a review, an analysis of the motions hearing got a lot of people extremely upset. For the most part, people were incredibly respectful in sharing their differences of opinion. There was one person who essentially told me that I knew nothing, but before I could respond, they decided to delete all their comments. So to me, that says they're not really interested in a response, so I'm not going to talk about that any further. But like I said, a few people were somewhat upset by my opinions that I shared yesterday. Now, as you know, I actually encourage people to share their own opinions on my channel, and I certainly have no issues with people sharing their opinions when their opinions are different to mine. I will admit, I do have issues with people sharing their opinions when it turns out that their opinions are actually just a verbatim repeat of opinions stated by another creator. That's not really sharing your own opinion. Now, I know that for some people, credentials mean so much more than demonstrated knowledge and analytical and critical skills. That said, having experienced firsthand the sort of vicious behaviour that can be directed towards content creators on YouTube, I chose long ago to maintain my privacy by not sharing my identity or my credentials. I let people decide for themselves whether what I have to offer is worthwhile, regardless of what credentials I may or may not have. Now, sort of moving on from that, one of the things that I highly value is the importance of self-reflection, meaning that it is important to take on board other people's questions, other people's criticism, and those instances when other people disagree with you. And not in a negative way, but in a way that allows you to question your own opinions, question your own knowledge, maybe even further your own knowledge, which of course is crucial for personal development. But in the case of someone who has a YouTube channel, someone who is a creator with the potential to influence many people, I think it is super important in terms of developing your channel and making sure that you are staying on track. So with that in mind, and taking into consideration the amount of criticism that I received over yesterday's video, I thought it would be important to actually take a step back and have a look at what some professionals have to say with regards to Detective Tagler most specifically, but in terms of law enforcement and how they handled this case. So while I was considering emailing various retired law enforcement professionals who are now well-respected YouTubers, one of my subscribers mentioned that Police Off the Cuff had actually discussed this. I've followed Police Off the Cuff since the Gabby Petito case. So naturally I was curious to find out what Bill Cannon's take on all of this was. And certainly based on his background, I think he is probably one of the most qualified people to discuss this case. Now, I will go through that in half a moment, but I will just mention that I have only pulled out excerpts from this particular episode of Police Off the Cuff. If you are not familiar with Bill Cannon, if you like what you see, then I will have the link below, and of course I will tag Police Off the Cuff, but I'll have the link below so that you can go over to his channel and watch the full episode. That way he's getting the views and you can see everything that was said, because it was a really good episode. I mean, his episodes are always good. Often he has other experts on and they have a bit of a panel discussion, and that's what occurred in this video. And of course his professional background means that he is really good at explaining things really, really clearly. So let's talk about his professional background and that of his guest. So let's talk about Bill Cannon first. Bill Cannon is a former NYPD sergeant, supervisor of the detective squad, meaning he's the big boss that has to make sure that, or when he was, before he retired, he had to make sure that his detectives were basically playing by the rules. They had to check with him for approval on things, obviously. And of course, if they messed up, if they did something that was perhaps beyond the law, essentially that can come back onto his shoulders as their supervisor. It's his responsibility to make sure that his staff are performing, let's say, within best practices, just to quote another content creator who seems to feel that by labelling everything as best practices, that means that it is correct. So, in terms of his profession as a NYPD sergeant, he is the sort of supervisor that someone like Detective Tagler or Detective Acosta would have had to contact in terms of where to go next based on the information they've found. It would be someone like Bill Cannon who would make the call and say, you need to seize that phone. Now, aside from having been a supervising sergeant of the detective squad, he was also a professor of criminal justice, and in addition to that, he still works as an international consultant. There are cases here in Australia where he has actually come in and acted as a consultant for Australian law enforcement. And that says a lot, because while we do have our share of shady law enforcement officers, we also do have quite high standards when it comes to detectives, forensics, crime scene investigators. You know, the cream of the cream. We do have extremely high standards within Australia. So having him come in as a consultant really shows you that he knows his stuff. Now, his guest on this episode is Professor Michael Geary. He is a professor of criminal justice. He is a published author. He's an attorney, and he's also a retired NYPD sergeant. So the panel on this particular video is really impressive. So I thought this was definitely something that I wanted to look at. So like I said, I have just used clips. I have left out portions of this so that if you like what you see, hop over and watch the full episode. He has covered other elements of Maddie's case. So even if you think, okay, well, I've seen enough of this one, and you're interested in hearing his perspective, like I said, hop over, have a look. I've followed him now for quite some time, and I feel confident in recommending his channel. So, with that said, let's jump into his video, and I'm just going to share my thoughts and observations along the way.
Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD.
I had forgotten when I was doing the intro how long he had been part of the NYPD, but 27 years. A lot of people don't have professional careers that last that long. They change careers or they burn out and retire early. 27 years is pretty impressive.
You know, in the Stefan Stearns case, perhaps we, being from law enforcement, made an assumption, and maybe our assumption can be proven incorrect, but I still think we are right. And our assumption is that when Detective Myra Tagler was questioning Stefan Stearns, a non-custodial interview, which means Stefan Stearns was not under arrest. He was free to leave. So it was a non-custodial interview. And when she asked him, and this was all recorded, is it okay if I look into your phone? And he responded, yes, yeah, you can look into it. And that is done across police departments all across this nation, of voluntarily allowing the police to do something.
Now, he's pointed out here that it was a non-custodial interview, meaning he was free to leave, and he'll come back to that and discuss why that is important later on in this video. Then he talks about the phone. Now, I know people are probably already typing in the comments section, that's not exactly what she asked. She asked to look at his maps. Yes, that is correct. She asked to look at his maps. He will also go further into this in the video. But what he said here I thought was very important to take on board. He's talking about voluntarily allowing police to do something. That's something that is done all across the nation. Don't forget, as you are listening to him, that as a sergeant responsible for the supervision of an entire detective squad, not just an entire detective squad, but the actual NYPD Detective Bureau, like that's huge. It's his job to know these things. So he's being humble here. We believe essentially allowing here for the possibility of error. But let's be real. This is someone who has done this for 27 years and knows precisely what is legal and what isn't.
And once they go into his cell phone, they find all of these horrific images that now, after they have found these images, absolutely, Stefan Stearns is under arrest and is not free to leave. That's where, when we talk about crossing the Rubicon of probable cause, that was it. He crossed into probable cause and he was under arrested. And we use that little sort of formula in custody plus interrogation equals Miranda. And at that point, Miranda would have been required because he was under arrest. But before that, he was not in custody. He even said to her, "Oh, do you mind if I move my car?" And she said, "No, you don't have to move your car right now. Just leave it where it is because the detectives just want to take a look." So if he even thought that he was free to go outside, which he obviously did because he volunteered to move his car. So we're going to get into this a little deeper.
Now, there will be occasions when he does have facts not quite right. And you see that with any creator who is not deep diving a case like we are. But essentially, just commenting on the being outside, whether he was inside or out, that's kind of not really overly relevant to what he's saying here, because he's basically pointing out that Stefan felt free enough to actually ask, "Do you mind if I go move my car?" Meaning that he did realise that he did have that freedom to go. Now, let's back it up a bit. He referred to this interview as a non-custodial interview. And then he talks about after this interview, at a later date, the interview which was done at the Orange County Sheriff's Office was, at that point in time, they had discovered the images, so they arrested him. And he refers to it as crossing the Rubicon of probable cause. Basically, they had probable cause, which they had enough probable cause so they could arrest him. At which point in time, he was in custody. He was also being interrogated, which at that point in time meant that he had to have his Miranda rights read to him. That is significant. Before that, he was not in custody. There was no requirement, no legal requirement for his Miranda rights to be read to him because he was not in custody. He was not arrested. It was not a custodial interrogation. So he's pointing out here there is a difference in requirements between a non-custodial interview and a custodial interview. This particular interview that is the focus of these motions was a non-custodial interview, and that is important.
But I think that the police acted within the scope of the law.
So let's be realistic here. We're talking about someone here whose job it was to oversee an entire bureau of detectives and make sure that they were acting within the scope of the law. Someone who also acted as a criminal professor. When he says, "I think the police acted within the scope of the law," there's a bit of humbleness there. He's given us his credentials, but he's not going to push his credentials on us now and say, "I'm 100% certain because these are my credentials." He's showing a bit of humility. He's being humble, saying, "This is my opinion." Basically, this is his opinion based on 27 years of professional knowledge and experience. So, sure, you could argue, well, he's only saying "I think," but this is someone whose job it was to basically manage an entire department. And when you are responsible for managing staff, the best way to do so is to lead by example and to lead alongside your staff. So what he's actually demonstrating here is basically not just an attempt to protect himself on YouTube, but also a remnant of a managerial style that basically showed respect for those below him and did not act in an autocratic way. And I know this for a fact because I have followed this channel, like I said, since the Gabby Petito case. I've heard plenty of other content creators who have worked alongside him refer to him in this manner. So, why am I saying this? Just to point out that, yes, he is saying this is my opinion, which is good, but it is an opinion that we need to remember that is based on considerable experience, considerable knowledge, and also this is the way I would expect someone who has been a successful manager of a large staff to react. He's not being autocratic. He's not saying, this is my opinion, you will accept it, or this is what I know, you will accept it. He is essentially saying, I'm offering you my opinion, you can choose whether or not you accept it or not. I know that's not entirely relevant at this point in time, but I'm just kind of preempting because I know there'll be people who jump in and say, well, he's not saying he knows definitely. But we just need to recognise the wealth of knowledge and experience that he's bringing to the table here.
Joining me today, you'll be thrilled, is retired NYPD Sergeant, Professor at Albertus Magnus College in Connecticut, an attorney. It's great to have an attorney on, especially with these legal issues. Welcome to the show, Professor Mike Geary. Welcome, Mike.
So we now have basically in front of us two former sergeants, NYPD, one of whom was basically the big boss. And we have two criminology professors. And then we have the added bonus here of an attorney. I certainly found their discussion to be extremely worthwhile.
This is, look at all of the time that the judge gave himself. So he obviously, this is a huge legal issue, and he may even ask for the assistance of other legal scholars because this is such an important ruling. Your thoughts, Mike?
Okay, so here's where we take a little break from his video to actually have a look at the fact that once again, Fox 35 got their information wrong. So you saw on that screen that they claimed that the judge was making his decision on June 30th. Now, my thoughts were maybe they meant prior to June 30th. And I thought, even that doesn't sound quite right because Judge Carson is extremely efficient. And my personal opinion is that he is going to actually have his opinion ready to publish much, much sooner than June 30. So I hopped into the court website just to get some clarification. So if you have a look, first of all, at this is just the raw thing that you find when you go on the website, and you look at the second big blob of writing with the little pink bit on the side. The pink bit says requested, but I've blown it up so you can actually see what's written here. So this big block is basically this is the minutes of the hearing that was just held. So it shows who testified. It talks about exhibits entered into evidence, arguments made by both parties, and then it says, court reserves ruling on all three motions. Court will issue a written ruling, court exhibit to be held in evidence by the clerk of court for appellate purposes, pre-trial and trial reset based on unavailability to try case within current trial period. Motions must be submitted to the court by 30th of June. So in actual fact, what Fox 30 has misinterpreted, basically, yes, the judge will be submitting a written ruling. There is no timeline given for when that written ruling will be released. The date of 30th of June is a deadline for all pre-trial motions. That's got nothing to do with the judge's ruling. That is to do with our friend Lizzie Borden, who loves to write 100 million motions. Basically, this means that any motions that need to be made need to be done so before the 30th of June. Otherwise, they're not going to be considered. Now, I just wanted to get clarification on this, so I went to the accompanying document. So I have actually done a bit of cut and paste here because this was 2 pages. It's just easier to put it all on 1 page to show you. But I will endeavour, and I said I would do so and I forgot, but I will endeavour to put this into my Patreon, the full document, so that you can hop in there and grab it if you want to look at the full document. But basically, this says exactly the same thing as we just saw. So the little bit of writing up the top, arguments made by both parties, court reserves ruling on all 3 motions, court will issue a written ruling. No timeline set. Then it talks about Court Exhibit A to be held in evidence, pre-trial and trial reset based on unavailability to try case within current trial period. All pre-trial motions must be submitted to the court by 30th of June. So there is clearly no deadline that the judge has set himself. Fox 35 have just once again made a mistake. And I feel confident that we will have a ruling from the judge quite some time before the 30th of June.
Bill, I think, we talk about consent, and waiver of the Fourth Amendment rights, that sort of thing, consenting to talk to the police. The only time the police have a duty to inform a criminal suspect of their rights, it would be under the Fifth and Sixth Amendment in a Miranda kind of situation where that person's in custodial interrogation. I think the prosecutor did a great job in her arguments to the judge by saying, look, none of the police officers had their firearms out. It was not a custodial or coercive environment. He was free to walk around, talk to the police. In fact, at one point, she said that the police were actually talking to Saffron Stearns, like shoulder to shoulder, outdoors, talking about, where poor Maddie was last seen and things like that.
Okay, just to tweak the information there a little bit, we know that situation of standing shoulder to shoulder was in fact Detective Tagler standing shoulder to shoulder with Stearns while she was looking at his phone. But the point he's making here is that Stearns was outdoors. He was not confined in any way. Referring to it as shoulder to shoulder shows that it's not a confrontational, face-to-face, in-your-face kind of interaction. Shoulder to shoulder is a far more informal interaction, and of course shoulder to shoulder basically allows a person space to leave should they choose to do so. So that's the important point that he is making here. It was outdoors. It was not a in-your-face kind of situation where he was being blocked in. It was a shoulder-to-shoulder discussion. He was well and truly able to leave should he wish to do so. Now, even before saying that, he's basically pointed out that in actual fact, the only time that police have a duty to inform a criminal suspect of their rights is in a custodial interrogation. After they have basically been arrested, had their Miranda rights read to them. This is not the situation, and he makes that clear as well, this is not the situation that occurred at the time that Stefan's phone was taken. It was a non-custodial interview. Basically, Stefan gave consent, which is essentially a waiver of his Fourth Amendment rights. It was non-custodial, it was non-coercive, it was in a environment where he could easily leave should he choose to do so.
That he was free to go. He actually asked to move his car, and he said, and they're like, no, don't worry about that. And that when he gave Detective Tagler the phone after she asked for it, he didn't expressly state, you can only look at my pictures, you can only look at cell phone record, the call record. I'm limiting you to text messaging, nothing like that. And I think the prosecutor brought that out really well.
So again, he brings up the fact that Stefan asked about moving his car, showing that quite clearly he realised he wasn't in a situation that he could not leave. He also brings up the issue with the phone. Stefan did not limit consent. Now, you could argue that initially, yes, when Detective Tagler asked him, can I look at your maps? He said yes to that. Maybe you could argue that is limiting consent. But after that, she asked, can I look at your history? There was no limiting of consent after the request to look at his maps. He did not verbalise at any time, you can only look at this. After he unlocked his phone for her and handed it back to her, he did not limit consent in terms of what she could then look at when he unlocked it. So, sure, we heard that moment when the defence lawyer commented about her looking at the photos on Stefan's phone, but legally, he did not limit consent at that point in time. This is a really crucial factor, which I know has been largely overlooked by people who are on the train of Detective Tagler did everything wrong, she should be fired. And I've heard people say that. And I believe that opinion was actually originally presented by a YouTuber.
And she told the judge, reminded the judge that looking at the issue of consent, you look at objective reasonableness. Remember, the police have to act reasonably, and were they acting reasonably considering the issues they were facing? You have a poor girl has been missing for 24 hours, and she's out there somewhere. Speed is of the essence. They asked for that phone. In fact, he even told them how to unlock the phone because they didn't know how to unlock the phone with whatever code number he had. I think the prosecutor did a great job.
Now, just a reminder, this is something he does for a living. He teaches criminology. He is a professor. So he knows what he's talking about here. So he brings up the issue of objective reasonableness. Did the police act reasonably based on the circumstances? He uses just one example of many circumstances that already existed at that point in time. He refers to the fact that Maddie has been missing for, now he was unsure of the time frame, but we know that it was already 24 hours that she'd been missing. And he points out that at this point in time, speed was of the essence. They didn't know if Maddie was still alive. So that gives objective reasonableness for their actions. There is also the knowledge of him resetting his phone, the knowledge of his lies, his claiming that basically this is where he went, when the tag readers show that that is not the case. So it was reasonable for the police or for Detective Tagler to request to look at his phone and then to later seize the phone. The choice to seize the phone came from the knowledge that he had factory reset that phone. He also points out, in terms of objective reasonableness, he was asked for the phone, he handed it over without objection, and he provided the PIN for the phone. He also, at that time, did not limit consent, meaning that whatever Detective Tagler chose to look at that point in time is covered by objective reasonableness. Essentially, the manner in which the detectives acted is the manner that would be considered reasonable based on the totality of the circumstances. So, in the eyes of the law, they didn't do anything wrong. Now, you could, of course, argue that there is a level of subjectiveness when you are looking at objective reasonableness. However, we know that at this point in time, there were a heck of a lot of factors which led to the decisions made by detectives at this point in time. They weren't flying blind. They had a lot of knowledge, they had a lot of data, and they sure as heck had exigent circumstances.
Stearns testified at the hearing saying that he believed detectives were just going to check my Google Maps. That was it. That was all I agreed to. He never said anything like that. Prosecutors said that Stearns gave the detectives verbal consent multiple times at the scene and noted that because they were standing next to each other, Stearns could see what the detectives were looking at on the phone. But Stearns' defense said that's not enough, and while acknowledging that legally Stearns was not in custody and was free to leave, suggested a reasonable person would have not have known that. While a warrant would normally be required to search private property, prosecutors say in this case, probable cause combined with the exigent circumstances of Stearns' factory resetting the device in an alleged attempt to delete evidence was sufficient for officers to take the phone. Stearns' defense argued that once the factory reset was done, there was no exigency because he had already acted. Judge Keith Karsten said he would weigh the arguments and issue a ruling at a later date.
I'm not sure if he was quoting an article there or if he was actually presenting his own summary, but they're now about to dig into what all that means.
So the legal issue, Mike, is, I mean, look, I'll say right here, this is police, it's true crime from a police perspective, but I think the police did everything right in obtaining his consent. And again, he was not in custody, which is one of the most important things.
Bill, you're absolutely right. And I agree with you. We look at things from a police perspective because we've done these sorts of things, asking people these questions in the past. And in this case, Stearns gave consent. Yes, you can. And the defense has to say, yes, he agreed to hand over the phone. But in his mind, he was thinking in his own head, they're only going to look at Google Maps. Well, the problem for him is the judge has to make his decision on objective indications of that consent. And the objective indications were that he never mentioned out loud of you can only look at Google Maps or something else. He never put any limits on it. He never directed the search. He never limited the search in any way verbally. So what was in his head doesn't matter because we don't have any objective evidence of what he really was thinking that night. What we do have objectively is the recording of Detective Tagler, who did a great job in this case, asking him, maybe look at your phone? Could you open it up for me? And he was responding positively. So I think the judge will ultimately agree with that Detective Tagler acted reasonably under the exigent circumstances. But I think also, as you pointed out, this case and the other case are tied in together. And this ruling is a huge ruling, and he wants to get it completely 100% right. I don't blame him. I think the judge is doing a great job.
So he makes a lot of solid points here. First of all, he points out that he basically believes the police did everything right in the way they obtained Stefan's consent. He was not in custody. And he qualifies that by saying, we've done these sorts of things. Essentially, they have the experience. They've done these things themselves. They know this for a fact because this is how they have also performed in the past. He again mentions Stearns' consent and points out that the decision that the judge is going to make has to be made on objective indications. That means he can't take into account Stefan claiming, well, this is what I thought was going to happen. He has to look at objective indications of consent. Those things that can be readily ascertained from listening to the interviews. He never put any verbal limits on the search. He never directed the search. He never limited what Detective Tagler could look at. And of course, we also have the testimony of both Detective Tagler and Detective Acosta that Stefan was standing right beside Detective Tagler while she was looking at his phone, meaning he could see what she was doing. So in terms of objective indications, all the indications that the judge will be basically basing his ruling on show there was no pushback from Stearns over them looking at his phone in any way. There was no removal of consent. There was no limiting of consent. And he was fully cooperative. So he's basically said here, it doesn't matter what was in Stefan's head because there's no objective evidence of that. Stefan can say whatever he likes, but there's no objective evidence of that. There's nothing that the judge can look at and say, this is solid evidence. He points out that in terms of objective evidence, what they have is the recordings. He praises Detective Tagler and says that he believes that she did a good job. She asked for consent continuously, and he responded positively. And he says that he believes the judge will agree that Detective Tagler acted reasonably under exigent circumstances. So this is coming from a former NYPD sergeant, an attorney, and a criminology lecturer. This is someone who understands not just the law enforcement side of things, but also the legality of it all. So him saying that the objective evidence is actually in favour of Detective Tagler.
Absolutely. This is a Detective Myra Tagler testifying yesterday.
I had considered editing out this clip because it is, I think it's about 5 minutes long, but I thought, why not? Let's just watch it again. I'm not going to add commentary. I may pause at one or two spots just to try and avoid copyright claims from the news station. But essentially, let's just listen through, and then I think that will help us to understand the argument that is subsequently made by these two after watching this.
Going in and out of St. Cloud.
Yes.
What times was it traveling towards or into St. Cloud?
It says eastbound on US 192 and Pecan Street at 13:05 hours, and westbound on US 192 and Academy Drive at 14:23 hours.
And you were equipped with this information at the time that you responded and met with Mr. Stearns in this case.
Yes.
Were you aware as to who the last person to have seen Madeline Soto alive or have seen her was?
Yes.
Who?
Stefan Stearns.
Was that consistent throughout a lot of law enforcement interviews that were conducted?
Yes.
After you get this information and your task is to assist in the investigation, what's the next thing that you do?
Detective Acosta and I respond to Kissimmee to their residence, and we meet with Detective Hunt.
When you say their residence, are you referring to Miss Jennifer Soto and Madeline Soto's residence?
Yes.
That would be on the Santa Maria Drive.
Yes.
When you get to the address, who is there?
Detective Hunt is there. There's other patrol deputies on scene, and Jennifer and Stefan.
So essentially here you've got Danielle Pennell establishing a timeline and also establishing probable cause. The tag reader info that didn't match, him having been the last person to see Maddie. She's also incorporating that within a timeline for efficiency.
Is there law enforcement conversing with either Jennifer Soto or Stephen Stearns?
Not at the time.
Who is the first person that you speak with?
Detective Hunt.
Does Detective Hunt relay information that he obtained during an interview with the defendant to you?
Yes.
What information do you recall receiving prior to your interaction with the defendant?
He stated that he had spoken to Stefan and Jennifer, and to his knowledge, Madeline had not made it to school, that Stefan had dropped her off near the school, and that they were supposed to go to McDonald's, but they didn't. And then he watched her walk towards the direction of the school, and then he went home.
Did you receive at that time any information about the sleeping arrangements on February 25th of 2024, the night before?
Yes. Detective Hunt told me that Madeline and Stefan had slept together in room number 4 because Jennifer needed to get more rest that morning.
Equipped with this information, did you come into contact with Stephen Stearns?
Yes.
How did you know who was Stephen Stearns and how to find him in the area?
Detective Hunt pointed him out.
Was your encounter with Mr. Stearns audio recorded?
Yes.
As a detective, what is your uniform, for lack of a better word, when you are at work? What do you wear?
Professional attire, like I'm dressed right now.
You're not in a police uniform when you make contact with Mr. Stearns?
I am not.
How about Detective Louis Acosta?
Same, not in uniform.
Does anybody approach Mr. Stearns with you and Detective Acosta?
No.
Where is Mr. Stearns when you approach him?
We're all standing behind his vehicle.
When you say his vehicle, who are you talking about?
The Lincoln?
So the defendant's Lincoln.
Yes.
And at this point in time, is the defendant handcuffed?
He's not.
So you have the addition of the sleeping arrangements, because that is part of probable cause. And then she's basically asking questions here to clarify the fact that it was a non-custodial interview and there was no pressure on Stefan. When she arrived there, Stefan and Jen were alone. They weren't talking with any law enforcement individuals. They weren't around any law enforcement individuals. She establishes the fact that Detective Tagler was not in a police uniform. She was in professional attire. And she also establishes the fact that it is only Detective Acosta and Detective Tagler, who are with Stearns when he's being interviewed. So she's showing quite clearly that it was a non-custodial interview with no coercion. He was free to leave.
Is the defendant free to leave?
Yes.
How is his demeanor, meaning the defendant's demeanor when you're interacting with him?
He was very emotionless, but otherwise able to answer every question that we had for him.
Did the defendant, seem groggy, confused, unable to communicate with you?
He did not.
Did the defendant respond appropriately to questions that you were asking?
He did.
Would you classify his behavior towards you as cooperative?
Yes.
Can you explain to the court, I know that you indicated that you're all standing in the back of Mr. Stearns' vehicle, but can you explain to the court where everybody is positioned?
Yes. I was standing on the left side of the trunk. Stefan Stearns was standing directly next to me. We were basically shoulder to shoulder. And Detective Acosta was standing closer to the wheel well on the right side and the corner of the car.
Was Mr. Stearns' path of travel impeded by either of you?
It was not.
Was Mr. Stearns free to leave?
Yes.
Did Mr. Stearns ever communicate with you either verbally or by body language or physically a desire to end the communication with you?
He did not.
Obviously, Mike, the questioning is leading to he was not under arrest. He was free to leave. You weren't dressed in a uniform, so because a lot of defense attorneys would say he was intimidated because the police were up in his face, these uniformed Gestapo agents, you know.
Right.
But detectives are dressed in what's called business attire. So Detective Myra Tagler made that perfectly clear. And on numerous, at least twice, the prosecutor said, and Stefan Stearns was not under arrest. He was free to leave. Is that correct? This is one of the biggest issues in this entire little conversation here, Mike.
So again, they're referring to the detectives acting in a reasonable manner. We have the account from Detective Tagler regarding Stefan's disposition. He was cooperative. He wasn't groggy or confused. He was able to communicate clearly, which is important, and that can actually be heard in the audio recordings. So again, the objectivity in terms of evidence, sure, he can claim that he was sleepy. Sure, he can claim that he was groggy, that he was cold, and that was affecting his mental capacity. But basically, that doesn't matter. That is irrelevant because he did not convey that at any point in this interview. And you can hear from the interview that that is far from the case. We get the discussion of their positions around the car, demonstrating basically he was not impeded, he was free to leave. And that's what Bill Cannon doubles down on here. He was not under arrest. He was free to leave. There was no police intimidation. They were not even in uniform. Essentially, this is demonstrating the reasonableness of the way the interview was conducted and the reasonableness of the behaviour of the detectives.
Yeah, it's an excellent give and take with the prosecutor because Detective Tagler is setting the foundation for saying, look, this was not a coercive environment. He was not surrounded by officers, glaring at him. There were officers in uniform. There were officers like she and her partner who were in business attire. She was standing right next to him by the car, shoulder to shoulder. They were having a conversation. At this point, Madeline was missing for almost 24 hours, like 16 hours at least, maybe 20 hours. And therefore, you have to find her. He is cooperating with them, talking to them openly. He didn't ask for an attorney. He didn't look around, and he wasn't intimidated. He didn't try to run away. They didn't have to catch him. He could walk around. He could talk to them, because at that point they still are not exactly sure all of everything that's going on, but they're trying to get all the pieces together as fast as they possibly can. So this testimony is setting the foundation for what's going to come and follow, which is, how did you ask for the phone? At any point did you ask to see the phone? And then after the judge already knows the actual physical layout and how the conversation went, you get to the consent issue. It doesn't look like they're allowing the judge to see that. It doesn't look like there was any coercion whatsoever, that consent was
Mike,
all part of that transaction.
Could I just
So essentially, he is saying here that they had objective reasonableness in spades. There was nothing untoward in the way that the interview was conducted, and they've basically established there was no coercion when it came to the issue of the phone. This was all done with Stefan's consent in a non-confrontational environment where he was free to leave.
just interrupt you for one second? There's an acronym I always remember, and it's called the VIK, V-I-K.
Mm-hmm.
And the permission must be given voluntarily, intelligently, and knowingly. And the reason also the prosecutor was asking Detective Tagler, was he at all confused? Did he seem at all like he didn't want to communicate? She was setting the ground to establish VIK. Voluntarily, intelligently, and knowingly, he gave his permission. And I think that was rather clear. And I'm sorry to interrupt you.
Oh, no, that's right.
We spoke about that before.
So that's got to be one of the best explanations I've heard. VIK, as in voluntarily, intelligently, and knowingly. Permission must be given voluntarily, intelligently, and knowingly. And through her questioning, the prosecutor has well and truly established that that was the situation when it came to Stearns's phone. And of course, this is coming from a retired supervisor of a detective squad, meaning that this is something that he would have basically impressed on his own staff in order to make sure that they were doing their job the right way.
And that is important also for the judge to say, well, yeah, when she asked him, can I look through your phone? And I also want to just back up for 1 second. Exigency. Don't forget, when all this was going on, Madeline Soto's body was not recovered. They didn't even know she was in fact unalived at that point. So exigency. There was exigency to finding her, to getting the evidence quickly, so that perhaps a warrant would have taken too long because she could have still been alive. That's what was in the mind of Detective Tagler. Mike.
That's right. And her conversation, as she said to the judge, he was clear-headed. He was sober. He was clear-headed. He didn't seem like he was under any sort of medication. He wasn't sleepy, intoxicated, high on narcotics. He was clear-headed and having a normal conversation with them. His affect seemed to be very emotionless, but he was very clear-headed and answered all the questions willingly. He was not showing any signs of reluctance. So therefore, he is VIK. He voluntarily handed over the phone. They didn't have to grab it out of his pocket while, he didn't drop it while he was running away. He voluntarily handed it over. He knew what they were asking, and he understood completely with clear head that he was they were asking to see the contents of his phone and to take a look at his phone. So therefore, it's knowingly, voluntarily, and intelligently given. So I think the judge is just being really, really careful. I think the prosecutor is being really careful. I mean, you could tell that is a very long foundational question, answer period. But I think they did a great job.
They do come back to talking about exigency in terms of destroyed evidence, but it is such an important point here, which I do feel was perhaps not emphasised enough by the prosecution, and that is that there was exigency in terms of finding Maddie. At that point in time, they did not know the full situation. They did not know that she was unalived. So there was the potential that trying to get a warrant for that phone could have potentially taken too long. They needed information like yesterday. So there is that factor to consider. And then basically he's telling us here that it is quite clear that they have actually satisfied the VIC test, the voluntarily, intelligently, and knowingly giving permission.
100%. I want to play a little bit of this from, we all remember this interview.
Are about. You're a very intelligent person. And I don't want you to discredit yourself by saying you don't know about all the pictures that are on your phone. I want to let you know you're not free to leave. You're being detained. Okay.
So at this point, he's informed of the fact that he is in fact under arrest and he is not free to leave.
I left out the bit where they tell Stefan what the charges are that are against him, because you know that YouTube really hates those kinds of words.
That is clear. Once he knew he was under arrest, what did he do? He invoked counsel. So at no time did he believe he was under arrest with Detective Myra Tagler. He would, hey, am I under arrest? No, you're not. You're free to go. So at no time. So that is one of the things that the judge will make his decision upon. In custody plus interrogation equals Miranda. And you see, when he was told that he was now in custody, he lawyered right up. Mike.
That is such an important point, showing that Stefan actually was fully aware during the interview with Detective Tagler that he was not under arrest, that he was free to go. Because by comparison, you have him the moment he is placed under arrest, he invoked his right for counsel. End of interview, no more conversation. So it is quite clear that he knew exactly what was going on.
Bill, it's excellent because it shows how quickly he realized what was going on. He knew the jig was up. When he's talking to Tagler several days earlier outside, and they're standing like right next to each other, leaning against the car, having a conversation, he was really sure that he was completely in the clear, and all he had to do was keep talking and being very vague, and he'd probably get over on everybody, because he knew in the back of his mind that he had destroyed all the evidence on that phone. So when he hands it over, he immediately says, "Oh, by the way, I unfortunately, I don't know how that happened. I factory reset my phone, but here you go anyway." You know, he was perfectly fine to hand that over. He didn't talk about his rights. He didn't ask for counsel. He didn't tell anybody he didn't want to talk to them any longer. He talked as much as he wanted to, but in that position right there, as you see the detective talking to him, and now he realizes, oh my goodness, the jig is up. He immediately invoked counsel. Two very, very different situations and with different outcomes. So I think the detectives respected his constitutional rights, in scrupulously observed his constitutional rights in both instances.
So that was also pointed out by the prosecution, the fact that Stefan knew, or at least he believed, that he had destroyed all evidence that existed on his phone. So in his mind, there was no problem with handing over the phone. And that actually does count as probable cause. The fact that he had factory reset his phone, and we now know twice, and believed that there was nothing to be found on that phone. You have the drastic contrast between the two interviews, where he does actually invoke his right for counsel once he's realised that he is under arrest. And what he said here is that basically he says that law enforcement scrupulously observed his constitutional rights in both instances. This is an observation from an attorney who also has that background of being a criminology professor and an NYPD sergeant. So he knows what he's talking about. This makes me feel all the more confident that when it comes to making a decision, that the judge will take all this into account and that those motions will be denied.
But I want to thank everyone for tuning in. Mike, your final thoughts.
Final thoughts, just to let everybody know that the police, in our estimation, the police did everything they could to and scrupulously observed, Stefan Stern's constitutional rights, and that they were not using any underhand or trickery or anything like that. They followed the law scrupulously, and therefore I believe that the judge will rule that the consent was given knowingly, voluntarily, and intelligently given, and all of that evidence will come in at trial against him.
So, as previously mentioned, I've followed Bill Cannon since Gabby Petito, so quite some time. So I feel extremely confident with regards to his experience and his knowledge. So it certainly makes me feel more confident in the results of what we're going to see from this motion. But also, somewhat importantly, I think it is significant that we have an assessment from an individual whose job it was to oversee the work of many detectives, that he is basically saying that actually Detective Tagler did a really good job and that she actually did not act outside what would have been considered objective reasonableness, meaning that her actions, the way that she got the phone from Stefan, the viewing of what was on the phone, the seizure of the phone, was legally acceptable. He talks about this objective reasonableness, and we also have this term VIC. Permission was given voluntarily, intelligently, and knowingly. These are all things that can be proven, meaning that essentially the defence really doesn't have a leg to stand on here. They've also here emphasised the extent of probable cause and that there were exigent circumstances. So the viewpoint put by both these gentlemen certainly supports law enforcement. And yeah, you can say, okay, they're going to be biased because they were law enforcement. But I have heard Bill Cannon comment when mistakes have been made. He doesn't gloss over things. So he's not just giving lip service here. If he's saying that he believes that Detective Tagler did everything right, that she did a particularly good job, he means it. So I hope this has managed to provide further clarity for people who were still uncertain, people who were on the fence perhaps. I do find that Bill Cannon has a way of explaining things clearly that allows people to understand what he's talking about. So I thought it was good to have an explanation from someone who has basically walked the walk. someone with 27 years experience supervising detectives. So he's definitely coming from a background which to us is extremely valuable in terms of looking at these motions and understanding whether or not law enforcement made a mistake. I've already stated my opinion. I believe that Detective Tagler did nothing wrong. I think that is very clearly outlined in the rebuttal that was put forward by the state, not just in the courtroom, but also in the document that they created. I believe that we can be extremely confident with Judge Carson that he is going to make his decision based on a really, really solid understanding of case law, based on circumstances, based on evidence, and of course based on testimony. It's not going to take the 2 months or whatever it is that Fox News is claiming. I think we will see a response from him much sooner than that. And I do strongly believe that response is going to be that these motions are denied. Now, I'm not normally one to piggyback off another channel in terms of a panel discussion like this, but I did feel that this one was particularly important to discuss because it was two experts discussing the case. So, no, you're not going to see me making a regular thing of doing reactions or commentaries from other people's channels. This is basically a rarity, something where I see a content creator with some really valuable insights to share, someone who has the background that we need in terms of providing honest, truthful evaluations of the situation from that professional standpoint. So I did feel it was a valuable discussion to look at. Now, with all that said, I will get back onto that derivative use review tomorrow. And hopefully those of you who haven't unsubscribed because of my views on this case in terms of the motions will join me for that. So on that note, if you're new to my channel, please subscribe. Also, please hit the like button. YouTube loves that. It gets me out in the algorithm, gets my channel seen by more people. And certainly, please do leave a comment below. Now, on that, I'm just going to, just given the topic that is being discussed here, I'm just going to request that people remember to show respect in the comments section to all other subscribers, to the channel that we've discussed here, and also to me. I feel proud that this is a supportive community here on this channel, and that for the most part in chat, everyone gets along, everyone appreciates each other's point of view, and you tend not to see negativity. So let's hope that continues with the comments in this video. So on that note, thank you, and I'll catch you in the next one.